Was the arrest of Luigi Mangione in Altoona, Pennsylvania legal or not legal? This is an issue that a judge now has to decide. And I want to point out that a lot of people have been asking for my opinion. I'm going to give it to you now. Hey, devil's advocates, what's your take on the recent motion by the prosecution? So let's get something out of the way right now. Thomas Dickey filed a motion a little over a month ago stating that the arrest in Altoona, Pennsylvania was illegal. And the basis of that, which I've went over and over again on many of my lives and long form videos that I continue to get questioned about, despite the fact that I have read the law over and over again, was that the law in Pennsylvania is a lot different than a lot of other places. It is not illegal in the Commonwealth of Pennsylvania to provide law enforcement with false identification unless a person has been identified that they're under investigation. Furthermore, it is not implied that you're under investigation because a uniformed officer is talking to you. That is not an implication of a uniformed or that you have been informed that you're under investigation. This has been upheld by the Supreme Court in the Commonwealth of Pennsylvania. Even people who are in law don't understand this very well. And I'm not a lawyer, so I want to get that clear for those of you who think, well, you don't have any right to talk about this because you're not a lawyer. Well, I'm also not an idiot. So let me read the law for you, and I'm going to show you because people want to know what my opinion is, and I'm going to give you my opinion. And I want to just preface, I understand if you think that I'm a jackass and I can't understand law and it's up for the courts to decide. Yes, you're right, it is up for the courts to decide. But what I'm going to tell you is why Thomas Dickey said it was an illegal arrest and why the prosecution said it wasn't an illegal arrest. And by the way, as a spoiler for those of you who are like, they upheld that it was a legal arrest, of course the prosecution's going to say it was a legal arrest. It is the judge's decision now to decide which of the two sides are correct. So it was never going to be a shocker. Never should have been a shocker to anyone that the prosecution was going to come back and say, yes, that was totally a legal arrest. That should not shock anyone. That was expected, and that's what just happened. And a lot of people are like, I thought the thing was going to get thrown out. I thought it was an illegal arrest. It may indeed be an illegal arrest, but it's no surprise that the prosecution was going to say that it's legal. So let's look at the law one more time from my perspective. And I'm not a lawyer, but I have had other lawyers tell me that I'm on the right path. I've had other people in law enforcement who have been officers, like, for example, the real Nathan Daly has caught this whole nuance as well on YouTube. So there are people who have experience in law enforcement and law who are saying the prosecution is probably wrong, is going to be wrong on this. Now, ultimately, it's the decision of a judge to decide which way it's going to go. And by the way, even if the judge rules incorrectly, the Supreme Court could once again intervene and say the judge was wrong. So this is one of those things that you can call me an idiot all day long if you want, because the prosecution knows the law. Apparently Thomas Dickey doesn't know the law. But let me reiterate the whole argument. So let's pull this up on screen real quick for you. Here is Pennsylvania General Assembly law. The statute that we are talking about is 4914. That's the section. This is from CA, which is, so it's Title 18, Pennsylvania, the Consolidated Statute, Section 4914. This is on basically false identification. So that's what we're going to focus on right now. If you look on screen, and I think we got it blown up about as big as I can go without going off the screen. This is from Pennsylvania's General Assembly, Section 4914. The law reads, a person, this is about false identification, a person commits an offense if he furnishes law enforcement authorities with false information about his identity after being informed by a law enforcement officer who is in uniform or has identified himself as a law enforcement officer that the person is subject to an official investigation of a violation of the law. This is the key part, that part right there where it says, after you have been informed you're under investigation by a uniformed officer. Yes, Luigi Mangione was detained by uniformed officers. He was not, however, informed that he was under investigation. And in fact, the prosecution fails to seem to realize that the Supreme Court dealt with this exact same issue on multiple court cases before and has ruled that the way this should be interpreted is literally, you must be informed, and it cannot be implied that because you're in uniform that you're under investigation. You must be informed that you're under investigation, or it's not going to be upheld, because the reason, and what we're going to see from the court documents, I'm going to show you so we could try to put some of this to bed for some of you. The court specifically said, we have to understand why it was written the way it was written. When a law is written, We have to uphold why it was written the way it was written. And the fact that they specified in the law that it's after being informed you're under investigation, it is not to be implied that having a uniformed officer ask you questions means that it's implied you're under investigation. That is not true, and you're going to see this in detail. We're going to look now, for example, at the case of the Commonwealth of Pennsylvania versus Mrs. Kitchen, 2018, Talicia Kitchen. And basically, I don't want to read this whole thing for you, but basically, she was pulled over for some drug offenses. And during that stop, an officer pulled her over because he saw her basically fail to make a turn signal. And so he turned on his sirens. She pulled over. He asked her name. She gave him false identification, a false name. Granted, it wasn't a false ID. We're going to get to that at the very, very end of this. There may be a small nuance between whether or not somebody verbally gives you false identification or provides an actual false ID. But the kicker you'll see at the end is it probably doesn't matter whether it's a false ID, as in a fake driver's license, or whether you just gave them the wrong name and birth date. Those are upheld as okay to do. You can provide law enforcement with false identification. The gist of this article, which you can see, this is at caselaw.findlaw.com, and you can look up this case, the Commonwealth of Pennsylvania versus Talicia Kitchen. But the gist of it is that the Supreme Court upheld that of all the things that she did, providing false identification and her wrong name and her wrong date of birth to police officers was not a crime, because the law specifically states the officer had not informed her that she was under investigation. And if you have not been informed you're under investigation, you have committed no crime, even by telling an officer a fake name or fake ID. They upheld other parts of the arrest, but the actual providing of the false ID, the Commonwealth charged the appellate with possession with intent to deliver controlled substance, possession of controlled substances, and false ID. Ultimately, the appellate's claim basically was that the false ID statute is going to be tossed out. The reason being is they stated in here in these documents, because the law specifically states that you're only guilty of providing false identification to an officer after you've been informed, and the officer had not informed her that she had been under arrest. And again, the state did argue in this case, well, it was obvious she was under investigation. There were sirens that pulled her over. The counter to that was you always have to pull over if there's sirens going on, and you always must answer questions of police. That's understood, but that's not admission of a crime, and nor is it even that you're under investigation. You just simply have a duty when you have a siren on to pull over. You can't just keep on your merry way going, well, I didn't do anything wrong, so I guess I'm not pulling over. So it's not good enough that you have sirens on. It's not good enough that uniformed police are asking you questions. You have to be informed very specifically that you're under investigation. And again, I don't want to read this all to you. I'm trying to go slow enough on the screen where you could zoom in if you want to, or you can find the website and go read it for yourself. I'm trying to find the big key points for you. Basically, so our first impression of the express language of the false ID statute coincides with the appellate's interpretation. The state does not specifically state that a person may be informed of an investigation by inference alone. Meaning, just because the officer is standing in front of her and that lights and sirens are on, you cannot just infer that you're under investigation. They agreed. That's not enough. You have to actually be stated you are under investigation by a law enforcement officer. The use of the term informed in this context strongly suggests that the legislature intended a statutory element akin to a formal notice requirement, rather than imposing an additional mens rea element focused on the accused's inferential knowledge about the presence of an investigation at the time he or she has presented false credentials. Let me break that through the universal translator, since a lot of you aren't law people, and I get it. What it's saying is exactly what I've been saying. It is the fact that the law states that you must be informed, in quotes, means that they did not want you to just infer that because an officer is asking you questions or sirens are on, that you're under investigation. They specifically called out on the law. It is after you have been informed that you're under investigation. Luigi Mangione was not informed that he was under investigation. That is actually agreed to in the prosecution statement, where they said this was totally illegal or a legal arrest. And it's legal because when we asked Luigi Mangione for his identification, he gave us a false name, and at that point he was under investigation. That is not true. Thomas Dickey pointed out that they did not tell him he was, in fact, they specifically told him he was not under investigation for 17 minutes. And it was only after 17 minutes did they say you're under investigation. So everything that happened before that, including presenting them false identification, was not against the law, according to Thomas Dickey. The prosecution's response is basically, in my opinion, because you're asking my opinion, them not understanding their own law. Well, Mr. Mangione was totally detained lawfully as soon as he provided false identification to a police officer. Well, that's not what the Supreme Court has said. The Supreme Court has said you can't, it's not illegal. And in fact, there's a use of a word, with impunity. A person can provide false, I'm trying to find it for you. A person can provide false identification to a police officer with impunity, which means with no punishment whatsoever. You can't be punished for providing, here it is, right here. The majority's view, that authority does not require the driver to provide accurate identification under the statute of false identifications. Rather, it allows the driver to provide false identification to a police officer with impunity, which means without punishment. I can lie to a police officer on the side of the road about my identity with impunity, without punishment whatsoever, because it's not a violation of the law. And that's the way the law has been interpreted. Furthermore, and I realize most of you don't like ChatGPT, but I want to end right here because, again, I could go on reading legal documents and you'll go to sleep all day long, and I get it. Understand, watch these things. This is ChatGPT. When I asked ChatGPT, hey, look at what I asked it. The Supreme Court made it clear that a person can provide false ID to an officer if they've not been informed they're under investigation. However, in the case cited, it involved a person giving a false name and not providing an actual false ID or driver's license. Does it make a difference? Because this is what we're really asking about in Luigi's case. Is it because he provided a physical driver's license that's the real kicker, and that's what I'm missing maybe? Is that what I'm missing? Is it because, again, providing false name and identification to a police officer if you haven't been informed you're under investigation is not a crime in Pennsylvania. I don't know how to say it more clearly. I know I'm not a lawyer, but that's what his lawyer is saying. That's what I'm saying. That's what other lawyers have said. That's what other police officers have said when they looked at this law. Actually, technically, it does say it's not against the law to tell an officer a false ID if you haven't been informed you're under investigation. And the prosecution even admits that he hadn't been informed. It was implied he was under investigation. It should have been obvious to Mr. Mangione that he was under investigation. Those are the kind of language they use. And the Supreme Court says, no, bullshit. It is not implied. The law specifically says you have to be informed for a reason. And it was upheld in multiple court cases. Now, listen to this. The distinction between providing a false name verbally and presenting a false identification like a driver's license could indeed have important legal implications, though it would depend on the specific circumstances. In Pennsylvania, Title 18, Pennsylvania constituted statutes, section 4914, specifically addresses the act of providing false information to law enforcement. The statute applies to, look at the green section, both verbal false statements and written documents like a driver's license under different provisions. So they explain a little bit more. False ID or driver's license, here's the green section. For a false ID, the analysis would still resolve around the same principle, whether or not the individual was informed by the officer that they were subject of an official investigation. If a person presents a false driver's license or any other form of identification, the same rule would apply under the reasoning of the case. In this situation, presenting a false ID could still be considered a violation of the law if the individual was notified that they were under investigation. So all of this, whether Mangione just told them, hey, my name's Mark Rosario, or he gave them a false ID saying his name is Mark Rosario, neither one, is what this is saying, would be technically illegal unless he was informed by the officer he was under investigation. And it's pretty clear the officers did not inform Luigi Mangione he was under investigation. Legal interpretation and summary is coming up, and then we'll finish this video. Even though the case primarily addresses false names, the underlying legal reasoning would likely apply to false identification as well. If the officer did not inform the person they were under investigation, providing a false driver's license would not, in and of itself, automatically constitute a crime under the state. Listen to that carefully. That it's not just an issue of, oh, well, it was a driver's license. It would have been okay for Luigi Mangione to give him a false name, maybe, but not a driver's license. No, this is saying the legal document, a driver's license, would essentially fall into the same protection. If Luigi Mangione, that's going to be the key, if Luigi Mangione was not informed he was under investigation, and it was just supposed to be implied by the fact that he was being surrounded by police officers, it is not good enough. He has to be informed. Thomas Dickey's complaint is Luigi Mangione was not told he was under investigation for 17 minutes, and that's when he was Mirandized, and that's when he stopped giving information. So everything prior to that was not being told he was under investigation, and therefore not a violation of the law. Summary, the legal principle in the Commonwealth versus DS would likely apply to both verbal false statements and the presentation of false identification, provided the officer did not inform the individual they were under investigation. That's it, folks. It's all a matter of two things. One, did the officers inform him he was under investigation or not when he provided the false ID? It appears to me from their own statement that no, they did not inform Mr. Mangione he was under investigation. He should have implied that by the fact that he was being questioned. That is not what the Supreme Court has upheld. They're wrong about that. Number two, the real kicker comes on what the judge is going to do. So Thomas Dickey has made an argument. They violated the law because he was not informed he was under investigation. The prosecution came back now and formally responded. It was totally illegal because Mr. Mangione should have understood he was under investigation, and as soon as he provided false identification to an officer, that was against the law. That is not true in Pennsylvania, in my opinion, nor in Thomas Dickey's opinion. Now it's up to the judge. Will the judge uphold the law? Will the judge look at the case law? Does Thomas Dickey have to remind the judge of the case law and the Supreme Court upholding what the rule is? Or does the judge just smart enough to figure that out on their own? It's all going to be dependent on that. And if the judge rules wrong and then the judge is like, yeah, you can't provide false ID to an officer and doesn't know their own law, a higher court could once again say, you guys don't seem to understand how to read the law. The law was specifically written with the statement after an officer is informed you under investigation, and we've upheld this before, and so it could be overturned. So lots to happen. But just once again, you wanted my opinion, that's my take. Thank you for listening.